What's up, fellow entrepreneurs? Today I want to discuss FLSA for California employers, key rules, conflicts, and risks. But first, I'm an attorney, but I'm not your attorney, so please seek competent legal representation for your specific needs. All right, let's talk about it. Most California employers know they must follow California labor law. What surprises many is that they must also comply with the Federal Fair Labor Standards Act, or FLSA. When those laws conflict, employers generally have to follow whichever rule provides greater protection to employees, and in California, that's usually state law. The FLSA establishes the federal baseline for wage and hour compliance. It governs minimum wage, overtime, record keeping, and child labor restrictions. But for California employers, the federal standard is often only the starting point. Take overtime as an example. Under the FLSA, overtime generally starts after 40 hours in a work week. California adds daily overtime after 8 hours in a day, double time after 12 hours, and special seventh-day rules. California also has a much higher exempt salary threshold and a stricter duties test for exempt employees. One of the biggest mistakes employers make is assuming that if an employee qualifies as exempt under federal law, they're automatically exempt under California law. That's not necessarily true. An employee can satisfy the federal exemption standards and still be non-exempt in California, creating exposure for unpaid overtime, meal breaks, and rest breaks. Here's a common example. An employee works 12 hours on Monday and only 4 hours on Tuesday. Federal law may not trigger overtime yet because the employee hasn't exceeded 40 hours for the week. California law, however, already requires overtime and potentially double time for part of Monday's shift. Employers relying on federal-only payroll settings can miss this every pay period. The best defense is proactive compliance. Review employee classifications, audit overtime calculations, verify payroll system settings, and make sure your policies meet California standards, not just federal requirements. Waiting until a wage claim arrives is often the most expensive way to discover a compliance issue. Until next time, be productive.